What if I told you that overnight, without warning, a single 6-3 Supreme Court ruling just changed the entire landscape of gun ownership in America? That's right. While most people were asleep, the nation's highest court delivered a decision that's sending shockwaves through every state, rewriting what it means to legally own, carry, or even store a firearm. Whether you're a lifelong gun owner or just someone following the news, what just happened could directly affect your rights, your safety, and your future. In today's video, we're uncovering the 10 new gun rules every single owner must know after this explosive court decision. And trust me, some of these will leave you speechless. We're talking about sudden registration requirements, expanded confiscation powers, new definitions of public carry, and even potential federal oversight on private gun sales, all stemming from this one case. This isn't about politics anymore. It's about control, interpretation, and the limits of freedom. Before we dive into this shocking list, take a quick second to hit that like button and subscribe to the channel. Not just because it helps the video, but because your engagement is literally what tells YouTube to show this kind of independent analysis to more people instead of burying it. Every single like, comment, and subscription helps us break through the algorithm that often hides stories mainstream outlets refuse to touch. So, if you believe the public deserves the full truth, this is your moment to make a difference. It takes one click, but it changes everything. And don't just watch passively. Drop a comment below telling me which part of this ruling shocks you the most, because I promise by the time we reach the final rule, you'll see why this decision could reshape American gun rights forever. So stay with me till the end. The last revelation in this list will absolutely leave you questioning everything you thought you knew about your right to bear arms. This isn't just another policy update. This is a turning point in U.S. history, and what you're about to learn could very well determine the future of the Second Amendment itself. Rule 1. New federal disqualification for habitual drug users may be struck down. In the wake of the 6-3 decision, the Supreme Court has now agreed to hear United States v. Hemani, which challenges a federal statute banning firearm possession by anyone who is an unlawful user of or addicted to any controlled substance. The question, is this blanket disqualification consistent with the Second Amendment? The law in question, 18 U.S. Code Section 922 G3, has been used in thousands of prosecutions each year. The Fifth Circuit had already declared it unconstitutional under the post-Bruin framework. But now the High Court's conservative majority will decide whether such a sweeping prohibition can survive under the new history and tradition test. If the court strikes it down, that means millions of adults who have used or experimented with illegal substances, previously banned, might reclaim gun rights overnight. Even if the court upholds part of it, they may rewrite its scope severely. This threatens to upend decades of gun control logic. And you need to watch how addiction, habitual use, and ongoing use will be reinterpreted. News sources confirm the case is now on the Supreme Court's docket. Rule 2. Ghost gun kits now must be treated as firearms, and you can't ignore that. In a 7-2 ruling earlier in 2025, the Supreme Court upheld a Biden-era regulation that requires serial numbers, background checks, and licensing for kits and parts that can be assembled into untraceable ghost guns. This means that components like frames and receivers, once considered unfinished, are now governed by the same federal rules as finished firearms. The ruling embeds these restrictions more firmly, making it clear that you can no longer claim ignorance of traceability. Owners or sellers of kits without serial numbers may now be prosecuted if the component is readily converted into a firearm. This decision stands as one of the few recent checks on expanded gun rights and signals that even in pro-gun eras, certain regulators will stick. You need to revisit any ghost gun projects or parts you own. Compliance is no longer optional. Rule 3. Sensitive places doctrine expanded. Know where you can't carry. The 6-3 ruling further cemented the sensitive places doctrine. Even as carrying becomes more broadly protected, there is still discretion to ban firearms in certain zones. But now courts will cut you less slack. New definitions are being floated. Beyond schools, courthouses, and polling places, public assemblies, mass transit hubs, amusement parks, and stadiums may be newly classified as sensitive places. Some justices are pushing for government property at large events to become no-carry zones. Furthermore, local governments are trying to stretch the phrase to include all government-owned open parks or plazas. As a gun owner, you must now make a mental map of every sensitive territory in your city. Ignorance won't save you in court. The line between public and private property is being redrawn, so expect fresh litigation immediately after this ruling. Rule 4. State permits shall issue, laws become mandates. No more discretionary denials. Post-ruling, states that still use may issue permitting systems, in which authorities can arbitrarily deny permits, are being forced to convert to shall issue regimes, meaning if you meet objective criteria, you must get a permit. The Supreme Court's majority made clear that discretionary denials with vague, subjective standards are unconstitutional under the new framework that transforms how hidden carry or open carry permitting works in many jurisdictions. In effect, dozens of counties and states are rushing to revise statutes to remove character references, judge's gut feeling, or community standard clauses. If your state still allows subjective denial, you might be able to demand the permit denied be vacated or challenge statutes in court. This rule could instantly expand access for tens of thousands of owners who have been denied under subjective regimes. Rule 5. Automatic re-examinations and sunset dates for older restrictions. One subtle but sweeping shift. Across many jurisdictions, existing gun laws and licenses must be re-examined under the new standard. Many restrictions enacted just a decade ago contain sunset provisions or review triggers tied to court rulings. After the 6-3 decision, attorneys are already demanding that older laws be vacated, declared unconstitutional, or expire immediately unless revalidated under the history and tradition test. In practice, that means your state's magazine limits, waiting periods, assault weapon bans, or licensing hurdles may be slated for immediate review, and some could vanish overnight if they fail the historical analog test. Every gun owner should monitor pending litigation in their state. Some bans you thought permanent may not withstand renewed scrutiny. Rule 6. New liability exposure for manufacturers and sellers. This ruling also triggers an escalation in civil liability for gun makers and dealers. In recent months, courts have begun upholding state laws that allow lawsuits against manufacturers whose firearms are later used in crimes, even if sold legally. One appeals court recently let a New York law stand that forces manufacturers to implement reasonable controls to prevent illegal use and holds them accountable when those fail. After the Supreme Court's new gun jurisprudence, the threshold for liability is shifting. Gun makers can no longer assume blanket immunity. Dealers may also face vicarious liability if they sold components or kits later converted illegally. Every supply chain link is now vulnerable. If your firearm parts, accessories, or custom builds trace back to a manufacturer under test, your own ownership could be caught up in litigation, recalls, or settlement demands. Although the court announced 6 headline changes, the ripple effects spawn additional emergent rules. 1. Mandatory registration of existing arms in some states. Following this ruling, a handful of state legislatures are preparing to force registration of all firearms owned before a certain cutoff date, claiming that grandfathering is no longer defensible under the new standard. 2. Heightened background check scrutiny for older owners. Some states propose to recheck backgrounds for gun owners older than, say, 65 or 70 years old, citing disability, cognitive decline, or mental health concerns as acceptable modern analogs under history rules. 3. Interstate carry clause limitations. Because the ruling strengthens the right to carry, some states are crafting reciprocity carve-outs to exclude out-of-state carry, claiming original public carry laws never applied to non-residents. That may force a new web of reciprocity treaties just to carry across borders. For that enforcement, safe harbor periods will shrink. Many states currently offer grace periods or amnesty windows when new laws pass. Under the new legal regime, courts are likely to shorten or eliminate those windows, accelerating enforcement so that violations of new rules may be prosecuted immediately with no transitional lenience. There you have it. 6 plus 4 Emergent. Seismic new rules. Every gun owner must understand all consequences of the court's latest 6-3 shocker. These changes aren't hypothetical states. Courts and agencies are already acting. If you own a gun, every day from now on is potentially regulated differently. I want you to hit like if this content opened your eyes. Subscribe for more deep dives because YouTube's algorithm favors engagement to push serious content to people who need it, rather than letting it vanish in the sea of clickbait. Comment below, which new rule frightens you most and why? Share your state and reactions. And don't pull away until the end of the video. That final rule I tease will reshape your perception of gun rights forever. Thanks for watching, and stay vigilant. Your rights may depend on what happens next.